Lots of amazing things happen when creative minds collide and institutional structures provide flexibility for learning environments. The collision generated the First Amendment on Trial debate series and features 4 debates focused on freedoms afforded by the First Amendment. These debates are made possible by a grant from the Free Speech Center at Middle Tennessee State University. Professors Ann Summerall-Jabro and Jameson for designing an inclusive experiential learning experience, or learning by doing, that involves 3 academic units at Robert Morris University: communication, political science, and the Academic Media Center. We're all about intellectual experiences at RMU, and this one includes our audience too. Students from the Civil Rights and Civil Liberty classes prepared and will present compelling arguments the legal system would advance when an aspect of the First Amendment is on trial. The Academic Media Center assisted with empowering us to include you in this experience through cameras, audio, and technology. And we, students from Public Relations and Social Media class, Brittany Claybaugh, Kayla Carbert, Jackie Medvid, Jules Schmid, and Lauren Camito, developed a public relations agency, Golden Strategy and Design, to develop and launch a campaign to entice you to participate. There's no winners or losers from this experience because we all learned something instrumental about our disciplines in real time. And you're learning to listen effectively, think critically, and render a judgment on the quality of the arguments presented. At the conclusion of the show, you'll be asked to vote for the debater that presented the most compelling case. Thank you for joining us today and listening intently to the arguments presented. And now to the debate.
Thank you, Brittany. I'm Professor David Jamison from Robert Morris University. Hello to all of you and welcome to this segment of the First Amendment on Trial. Throughout this series for the next 4 weeks, we will have an opportunity to explore in depth all the aspects of the First Amendment, the personal freedoms that we enjoy as guaranteed by the First Amendment to the Constitution. Freedom of religion, freedom of speech, freedom of the press, and freedom of assembly and petition. To help us understand these freedoms, Robert Morris University political science students have researched significant cases from U.S. Supreme Court history. In these programs, you will hear the arguments to the court in cases testing the First Amendment. As in a real Supreme Court appeal, each advocate will argue their cases, and each one will answer questions from a presiding judge, questions from the bench. Today's First Amendment topic is freedom of the press. In a case suggested by the famous Pentagon Papers decision, our advocates will explore potential conflict between two vital American values, our national security and the role of a free press in a free society. Our advocates for this case are Brianna McCann and Travis Sapp. Brianna is a junior at Robert Morris, majoring in political science, and Travis is a senior, majoring in political science and criminal justice. Representing the judiciary as our presiding judge is the Honorable Anthony J. Moretti. All rise.
Good afternoon, everyone. You may be seated. And I will remind everyone in the gallery during the oral argument to please refrain from making any comments or any distractions to either of our attorneys or to the bench. I will now hear case number 19-211, United States of America versus Washington Post Companies. Counsel, please enter your appearances.
May it please the court?
Mr. Sapp, good to meet you.
In 1967, the Secretary of Defense, Robert McNamara, serving under the administration of President Lyndon Baines Johnson, commissioned a study of the history of the United States political and military involvement in Vietnam from 1945 to 1967. The study sought to examine how the United States became involved in the Vietnam conflict. The completed study was classified as top secret. 15 copies were made. Daniel Ellsberg, a military analyst employed by the RAND Corporation, stole 2 copies and released them to the Washington Post and New York Times. The papers then began to publish excerpts from the study in June of 1971. administration claimed executive authority to force the New York Times and Washington Post to suspend the publishing of the excerpts of the classified information. The government brought a motion in federal district court asking the court to order the publishers to stop printing further installments of the study. Both the District of Columbia and the Court of Appeals for the D.C. Circuit refused the government's request for an injunction against the Washington Post. The District Court for the Southern District of New York rejected the government's request as well, but an appeals court granted the injunction. This inconsistency between federal courts led to the Supreme Court hearing the case. Because of the seriousness of this issue, the case was expedited in the lower court and only took 9 days to reach the Supreme Court. The argument the federal government put before the court began with the fact that the publication of the materials poses an irreparable and grave danger to the United States. This justifies the government in imposing prior restraint. Secrecy and confidentiality are critical to the conduct of foreign affairs and making war. Secondly, the court should defer to the executive branch due to the fact that the executive is the controlling branch over foreign affairs. The executive is also the commander-in-chief of the armed forces of the United States. These roles of the executive branch make the executive the best suited to determine the effects of the publication. Lastly, in order to impose prior restraint, the government needs only to show a likelihood of harm due to the impossibility of predicting the exact consequences of the publication. This exemplifies a significant issue for the federal government and their most important duties. Carrying out the duties as stated in the preamble of the Constitution, in this case, to provide for a common defense. The government must also ensure the inalienable rights of its citizens, or in this case, the freedom of the press. The First Amendment does not trump the necessity to provide for a common defense. The publication of these documents does possess an irreparable threat and grave danger to the United States, but more importantly, threat to the interests of the United States in the region. That interest being the growing influence and conflict in the region. The purpose of the Vietnam War as stated. The fact that the documents at any level of classification are being published is reason enough for the federal government to impose prior restraint. In addition to being in possession of highly classified documents, the individual that is responsible for leaking the documents came into the possession of them illegally by committing a federal offense. Responsibility of documents lies with the executive branch of the federal government. As the branch responsible for both foreign affairs and war, the executive has the authority to deem these documents ill-suited for the public. In past decisions revolving around the First Amendment and in times of war, the court in their decisions has made a clear differentiation between cases during peacetime and during wartime. The First Amendment is not universal. It has its limitations, as the court has determined in previous decisions. In Schenck v. United States, a case revolving around an individual passing out pamphlets urging resistance to the draft of the First World War, Justice Holmes' opinion held in that case that many things are said in a time of peace that are such a hindrance during a time of war that no court could regard them as constitutionally protected. In the case of Neer v. Minnesota, the court held that there are 3 exceptions to freedom of the press, one of which being in times of war. Chief Justice Hughes' opinion held that the government may legitimately prohibit publications that they might not regulate in times of peace. The case of New York Times v. U.S. was tremendously flawed for a multitude of reasons. The 3 dissenting opinions of the justices make clear the flaws in that case. The first opinion is Chief Justice Berger's dissenting opinion. His opinion partly exemplifies flaws in this case. The opinion held that the protections of a free press at times can collide with the effective functioning of a complex modern government, specifically the effective exercise of constitutional powers of the executive. He also states that we did not know the facts. No district judge knew all the facts, no court of appeals knew all the facts, and no member of this court knew all the facts due to the haste at which this case proceeded, which also precluded reasonable and deliberate judicial treatment, and it was not warranted. The justice suggests the speed at which the case took place was due to strong judicial resistance toward prior restraint, but acknowledges that prompt judicial action does not mean unjudicial haste. The opinion of Justice Harlan also helps to portray the flaws of the case. He considered the court has been almost irresponsibly feverish in dealing with this case. The justice then goes into detail of how quickly the lower courts rendered decisions and how quickly the case was brought before the Supreme Court and decided. The justice blames a presumption against prior restraint for the speed at which the courts made the decision on the litigation. The justice goes on to say that the importance of the case should require ample time for the court to decide the merits of it. The justice also mentions a number of questions that had not been faced by the court during this case. The most significant of those questions being whether the threat to publish highly secretive documents in and of itself is a sufficient enough implication of national security to justify an injunction, on the theory that regardless of the contents of the documents, harm enough results simply from the demonstration of such breach of security. The second unanswered question was whether the unauthorized disclosure of any of these particular documents would seriously impair national security. The weight of the opinions of the high officers of the executive branch in regard to the risk to national security was also not during the case. Whether the newspapers are in retain and use the documents and the uncontested facts from the government possession, and the newspapers received them with the knowledge that they had been feloniously acquired. The justice states the potential consequences of erroneous decision are enormous. The time available to the courts has been wholly inadequate for giving the kind of consideration they deserve. The justice also states that due to separation of powers, the ability of the Supreme Court to rule on foreign affairs is limited, due it to being under the control of the executive branch. The ability of the court to challenge the executive branch on the matters is limited as well. The court also does not possess the ability to determine the impact on the disclosure of national security. Finally, Justice Blackmun's opinion held that the First Amendment is only part of the Constitution. Article 2 of the document places the power of conducting foreign affairs as well as the security of the nation under the executive branch. Each provision in the Constitution is important, and we cannot subscribe to the doctrine of unlimited absolutism for the First Amendment at the cost of downgrading other provisions of the Constitution. In conclusion, the standard of prior restraint, particularly in times of war, is far too high. This case should not have been decided in favor of the publishers, but rather in favor of the government.
Mr. Sapp, a question for you before you sit down. You make a very eloquent case for the idea of national security, the executive being in control in times of war, et cetera. Can you, through the research you've done, through the prior cases you have, articulate where you think clear examples of national security being threatened would have been obvious with the publication of the Pentagon Papers?
Well, in the Schenck case, you have the individual passing out pamphlets in order to harm the draft registry of the First World War. And it's not necessarily a harm to the Vietnam War, but the harm to the government would be the acknowledgement and the strategy against not necessarily Vietnam, but China overall, and the strategy that we're using against them to prevent communism from growing in the region.
Mr. Sapp, thank you. I will remind you that after Ms. McCann's presentation, you will have a 5-minute rebuttal. Ms. McCann, representing the Washington Post.
May it please the court?
Please.
A free press exists to act as a watchdog for the people to ensure that their government is operating within their best interests. But sometimes this means that information that the government does not want to get out does so. This issue is complicated by the idea of whether or not this information contains information that could be pertinent or harmful to national security measures. And we've seen this lately with examples such as Chelsea Manning or Edward Snowden. So the question becomes, does the government have the right to prevent publication and to censor the press's ability to publish this information? Court precedent says no. Returning again to New York Times versus U.S. from 1971, as my colleague mentioned, Daniel Ellsberg worked for the Rand Corporation, and he was working on a historical study of the U.S. involvement in Vietnam from 1945 to 1967. It is important to note this time the United States government was saying that we were winning the war in Vietnam, we were pushing back the North Vietnamese, and that we were fighting gallantly for freedom in South Vietnam. Some of this information found in the Pentagon Papers said the opposite. A memo from the Department of Defense was included in the Pentagon Papers broke this down numerically. The Department of Defense memo, and I quote, said that the reasons to stay in Vietnam were 70% to avoid a humiliating U.S. defeat, 20% to keep South Vietnam and adjacent territory from falling into Chinese hands, 10% to permit the people of South Vietnam to enjoy a better, freer way of life. Also, to emerge from the crisis without unacceptable taint from methods used, not to help a friend, although it would be hard to stay in if asked out. So clearly, that contradicts the public statements on the Vietnam War. It is important to note that those are the kinds of things included within the Pentagon Papers. So seeing this information, Daniel Ellsberg photocopied the studies in 1969 with the intent to disclose them. So he then went to Nixon's National Security Advisor, Henry Kissinger, as well as Senators William Fulbright and George McGovern, among others, to see if any of them would want to do anything with these papers. All of them ignored him, so he then went to the press. It was released to the New York Times and to the Washington Post, and articles using this information from the Pentagon Papers first appeared in the New York Times on June 13, 1971. Now, of course, the Nixon administration was not thrilled about this, so they immediately sought an injunction against the New York Times and the Washington Post, who was also publishing these papers, to prevent any further publication. And when it reached the Supreme Court, one of the main arguments on behalf of the New York Times was prior restraint. Prior restraint is the attempt of the government or another body to try and prevent the publication of material before it is published based upon the content because they think it will pose some threat. Now, in Neer versus Minnesota in 1931, this practice of prior restraint was deemed unconstitutional by the Supreme Court. And it was said that it must be shown that publication would cause an unavoidable, disastrous outcome if this was published. Now, this was not the case with the Pentagon Papers. As I mentioned, this was a purely historical study. Daniel Ellsberg photocopied this in 1969. It was published in 1971, and the report only went up until 1967. So there was no current military information that would have actually harmed service members who were in Vietnam in any way other than what they already faced on a daily basis. Furthermore, the Supreme Court presumes cases dealing with prior restraint to be unconstitutional. If a case reaches the Supreme Court where the government is trying to enact prior restraint, the Supreme Court presumes it to be an unconstitutional act, and therefore the burden of proof is on the government to prove that. It was ruled in this case that the government could not do so. And touching upon the executive branch argument that the president has the sole war-making and affairs powers, it is that the president cannot exercise censorship over the press just because of the fact that information about foreign affairs is coming out. The Supreme Court did rule in favor of the Times, filed a per diem brief, meaning that they acted in agreement as a court opinion. So that was short. The per curiam argument only said that the government had failed to meet the burden of proof to enact prior restraint. But concurring opinions touched deeper on these deeper constitutional issues found within the case. Concurring opinions by Justice Black, Douglas, Brennan, Stewart, and White were all very clear and explicit that this was a violation of freedom of the press. And they are absolutely correct. The people have a right to know, and the press gives them that right to know. Especially in the case of the Pentagon Papers, and looking at that Department of Defense memo for one, do the people not have a right to know that a war that will kill somewhere between 1,353,000 people on both sides, 58,220 of which will be Americans, is a war fought solely to avoid bad publicity for the country? I think so. And that's what the press does. It preserves the ability of the people to know the truth and the real motives behind what the government is doing. The unique powers, protections, and liberties of the press must be protected to ensure that the government is telling people the truth and actually acting within their best interests. So look at a modern case, such as Edward Snowden. In 2013, when he was a CIA employee and working for the National Security Administration, he leaked highly classified information that revealed that there were national, international surveillance programs that were going on, that were taking almost constant surveillance on most everybody in the country. And Snowden was, of course, disturbed by this. It's exceptionally Orwellian. And so then what he did is he tried to raise these concerns through the ethical back channels, things like whistleblower complaints, and he, very much like Ellsberg, was ignored, and also like Ellsberg, then turned to the press. He released these leaks to the press, and when it was first published in The Guardian, a British newspaper, then other newspapers began to pick it up, such as the Washington Post and others like the New York Times, now making it an American issue and an American freedom of the press issue. Now, it's important that Snowden did this because it raised awareness and discussion of personal privacy as the government was maintaining this surveillance and nobody knew. And by the press picking up this story, it made sure that people did know this. In fact, whenever President Obama was asked if there were any national surveillance programs, he said, no, nobody's watching you. So again, much like the Pentagon Papers, Snowden's leaks revealed a clear discrepancy between government statements and the truth. So I ask, is this not the same case as the Pentagon Papers? It is well within the rights of the press to publish and inform the people of government activity, even if the press is not happy about it. It is important because it forces the government to answer for discrepancies and to be open about the activities in which they are partaking for the people to know. The press must act as a watchdog and use their unique institutional guarantee, protections, and privileges to put the power in the hands of the people. It is not the place of the president or of the court to hamper this right in any way. The press has been acting on behalf of the truth and of the people's right to know it since its inception. Dramatic examples like the Pentagon Papers and Snowden show this and show the importance of the press's ability to give this platform to truth. After all, this is the government of the people, by the people, for the people, and it is crucial that the people are informed to be an active member of this democratic society. The court has upheld the press's right to publish the sources and materials, and it must continue to do so in this case. Justice Black, in his concurring opinion in New York Times versus the US, said it perfectly. In the First Amendment, the Founding Fathers gave the free press the protection it must have to fulfill its essential role in our democracy. The press was to serve the governed, not the governors. The government's power to censor the press was abolished so that the press would remain forever free to censure the government. The press was protected so that it could bear the secrets of the government and inform the people. Only a free and unrestrained press can effectively expose deception in government. Thank you.
Ms. McCann, very eloquent argument. Before you sit down and I allow Mr. Sapp his 5-minute rebuttal, and you will also get a rebuttal, a question as well for you. You speak of the Pentagon Papers being a purely historical study. And at the same time, you also acknowledge that Mr. Ellsberg's actions were clearly illegal, as would be defined by the idea of stealing, anything along those lines. So, do the ends simply justify the means because of the being a First Amendment issue, or is there something else here that allows us to simply look past Mr. Ellsberg's illegal activities?
We can certainly debate the ethics of what Daniel Ellsberg did or what Edward Snowden does. Anybody who illegally leaks things, we can absolutely discuss the ethics of that. But once that information is released to the press, it is their right to publish it. The press didn't steal the information, and they cannot be held accountable for the ethics or the means in which the person that stole it did so.
Thank you.
Thank you.
Promise both of you a 5-minute rebuttal. Mr. Sapp, you will go first.
May it please the court. Secrecy is paramount to the government to wage war, both in the 1960s and early 70s during the Vietnam War, well today. The case of Edward Snowden is similar in a way to Daniel Ellsberg. They both committed crimes. There are many means within the government to take your grievances about what has happened to higher-ups. The harm in Vietnam would not be caused to the service members if the Pentagon Papers were to be released, but rather to the overall larger interest of the United States. It would harm their ability to recruit. It would harm their foreign policy in the region with the South Vietnamese, because it showed that we were not really a true ally to them and only preventing our own embarrassment, and as well our interest of foreign policy in the overall region and against China. The American government does have the ability to determine what should or should be secretive and what should or should not be consumed by the public and published by the press. The Snowden case is not particularly the same in a certain way. Terrorism is a far greater threat than what was seen in the Vietnam War. The government at times must take overreaching actions to prevent catastrophe. The surveillance program of the United States and the secrecy and necessity of it should have been kept secret and should not have been leaked. Thank you.
Mr. Sapp, I appreciate your comments today. Ms. McCann, your 5-minute rebuttal.
May it please the court?
Please.
I would like to begin with this concept of secrecy in war making. That is a very slippery slope argument. Once you begin to say that the government can deem certain things secret, where do you draw the line? And then nobody knows anything, and again, it becomes an Orwellian society. Furthermore, whenever the executive is serving as the commander-in-chief, that is absolutely one of their roles. My colleague is correct in that. But it is important to note in the Pentagon Papers case in particular, war was never declared on Vietnam. So technically speaking, we were not in a state of war. Therefore, the president does not have those specific war-making powers in that way. So it's important to note, again, that this was a historical study. And as I mentioned before, ethics are another question. Once it is leaked, then it's the press's fair game to do with it as they wish. Again, we can have a debate about ethics sometime, but this is not the time nor the place for it. Looking at the idea of separation of powers also, foreign affairs is certainly another part of the role of the presidency. My colleague is correct about that as well. But in the case of both Edward Snowden and in the case of the Pentagon, this was by a U.S. citizen in a U.S. paper, and in that way, it is a U.S. issue. Furthermore, going back to the point of the fact that this could harm the government, especially in the case of the Pentagon Papers, by making them look bad to allies, sowing seeds of distrust, the answer to that is quite simple: be forthcoming in the first place on the part of the government. And to your point about Edward Snowden and terrorist acts, it absolutely makes sense why surveillance was going on in the first place. But given the fact that the government repeatedly lied about it as opposed to just explaining, that is where the press comes in to make sure that, again, this is a free press, a free country for everybody, and ensure that the people are informed. Thank you.
Ms. McCann, again, thank you for your comments to the court. Ladies and gentlemen, we have heard arguments for both sides of this important question. What's your turn? I ask those of you in the gallery and those of you who are also watching us via this simulcast to please cast your ballots.
Join us in the Academic Media Center for the First Amendment on Trial debate series every Thursday until November 24th.
I think it was about 4 decades later, because there are some key similarities: illegal activity, exposing, though, illegal activity of the government, and certainly the involvement of the press in publishing these documents, versus the idea of, is it right for people to do something illegal simply to ensure that a misdeed is made public? If you're looking at a key difference, however, and I think this is where we didn't have time to get into this discussion today, but I think one reason that people feel maybe Mr. Ellsberg was more honorable than Mr. Snowden was that Daniel Ellsberg chose to stay in the United States and face whatever legal challenges came his way, while Edward Snowden, fearing, probably very justifiably, that he would not get either a fair trial or perhaps would see his life unfortunately shortened, opted to leave the country. The challenge you always face as a private citizen, if you do indeed choose to take on the government, is to understand, while there are many rights you have, there also is this balance of activity between what is the government's rights or privileges or necessities in terms of protecting us, and what's also required in times of either peace or war in the First Amendment. With that, I bring back Brittany Claybaugh, who has the results. I want to thank Mr. Sapp and Ms. McCann for representing the first of our 4 First Amendment on trial programs here at University.
Thank you, Judge Moretti. And a big shout out to our student debaters who spent countless hours researching and writing their cases and presenting them for you today. Our audience members listened attentively and selected Ms. Brianna McCann for the winner of the case. Our campaign focused on making people aware of their First Amendment rights, and we've been successful too. Post your comments about the debate and our public relations effort on our Facebook page, The First Amendment on Trial, and join us for our next debate on November 7th, where students will be discussing how free is free speech in a public school. Thank you.